Good afternoon and welcome to NCIA's Industry Essentials Educational Webinar Series, our new digital platform featuring a variety of programs to provide you timely, engaging, and essential education when and where you need it most. My name is Brian Gilbert, the events manager here at NCIA, and I'm very excited to welcome you all to another episode in our Policy Council Conversation Series this afternoon. If you're just joining us, please do be aware that we'll be conducting Q&A at the end of the presentation, so pose any questions you have by using the Q&A board that you'll find available along the bottom toolbar in Zoom. Even if you don't have a question yourself, stop in the Q&A area throughout the conversation and give any questions an upvote that you find of particular interest. Now, let's get this show on the road. In today's session, our panelists will discuss the critical importance of cannabis research, the recent DEA rulemaking and NCIA's numerous objections, and the lawsuit against DEA, along with the resulting disclosure of the DOJ policy memo. Thank you to our audience, and shout out to all the NCIA members joining us this afternoon. And with that, please enjoy today's session entitled Policy Council Conversations, Just Say No, Keep the DEA Out of Cannabis Research, being moderated by Jody Avergan, the chair of White Collar and Criminal Defense and Investigations Group at Cadwallader, Wickersham, and Taft LLP, as well as the former Chief of Staff of the Drug Enforcement Administration. Before kicking it off, however, our Director of Public Policy here at NCIA, Andrew Klein, would like to address the current state of affairs across the country. Take it away, Andrew.
Thank you, Brian. Before I start, I want to just make clear that what I'm about to say are my personal views, or not necessarily the views of NCIA. Before we start talking about research, which is incredibly important, I just want to say a few words about the biggest issues facing our country right now. I believe firmly that all of us with platforms have to speak up. As the COVID outbreak hit, this administration ignored warning signs, decided to sit on the sidelines, and let governors decide whether they should shut down public activities. This dereliction of duty directly caused the loss of more than 100,000 lives and put 20% of our country out of work. Then we saw a Minneapolis police officer kill an African-American man on television. In ordinary times, we'd have seen our president speak to the American people from the Oval Office to help quiet tensions and unify the country. That never happened. Instead, the president did a photo op at a historical church and then summoned law enforcement and the military in a show of force, including increasing the authority of DEA to make arrests during the unrest in Washington, D.C. Of course, these are just two examples of the objective failures of this administration. As a reminder, this administration has done nothing to support the cannabis industry. In fact, this administration rescinded the Cole memo and is now trying to put the DEA in charge of research. And so here we are. I'll turn this over to Jody.
Good afternoon, everybody. Thank you, Andrew, for those important comments and your insight. And thank you to the NCIA for putting on this important webcast today. Just to give some context to why we're here, in late March, the DEA issued a notice of proposed rulemaking regarding licensing people or entities seeking to manufacture cannabis for medical research. This March NPRM followed an August 2016 NPRM that covered the same topic. It purported to do the same thing. The two could not be more different. The panel today is going to explore these issues a bit, both from the perspective of one of the people who applied back in 2016 and who, like all the other applicants for cannabis cultivation licenses post August 2016, when that hopeful NPRM came out, is still waiting for a license. We're also going to hear from her very talented lawyers and, of course, the NCIA. Everyone has a lot of interesting things to say, so let's get right to introductions. First, I'm your moderator, Jody Avergan. As Brian told you, I'm the chair of the white collar practice at Cadwallader, Wickersham, and Taft. I'm based in Washington, D.C., and in my prior life, I was an assistant U.S. attorney in Brooklyn, New York, then the head of the Narcotic and Dangerous Drugs section at Main Justice at DOJ, and I ended up as the chief of staff of the Drug Enforcement Administration. A lot of my practice involves issues emanating from the Controlled Substances Act, and I work quite a bit on DEA matters. Hopefully I'll be able to add some insight, but you have really a panel of experts. Our panelists will tell you a bit more about themselves, but we have Dr. Sue Sisley, who is the principal investigator for the Scottsdale Research Institute, which is involved in investigating medical uses of cannabis. She holds a license from DEA to study marijuana, but is limited to the single source cannabis grown at the University of Mississippi. She wants to be licensed to cultivate better quality marijuana for study. Matthew Zorn and Shane Pennington, litigators at Yetter Coleman in Houston, Texas, who have achieved some notable successes in pushing DOJ and DEA toward licensing issues, using the power of the courts and the Freedom of Information Act, and of course, Andrew Klein, the Director of Public Policy for NCIA. Everyone will talk to you for a few minutes about their perspectives and their roles and provide you with information, and I'll interject with some questions. Sue, why don't you get us started? And I understand you have some slides you want to share.
Yes, thank you so much, Jody. Let me dive right in. Gonna share my screen with you guys and show you some material. So, all right, first of all, I want to just mention that I am an internal medicine doc here in Arizona, and our Scottsdale Research Institute is focused on this mission to try to conduct rigorous controlled trials looking at inhaled cannabis only. So we only study smoked or vaporized cannabis flower as medicine, and we've selected that because we feel that it's the most efficacious. It is the core medicine, and all the extracts and derivatives of that are suboptimal versions of the natural flower. And the last bullet point is the most crucial part of why we're talking about this today, is because in order to persuade health insurance companies to pay for cannabis the same way they pay for standard pharmaceuticals is to achieve FDA approval. And the only way we're going to do that is through conducting these FDA controlled trials. And so that's why we our mission is so essential. And you'll see here, this is the study that we're probably best known for, although we do all kinds of research on flower for treating pain and opioid substitution, but we spend a lot of energy looking at cannabis for treating PTSD. And this, you'll see, this was one of the renewals we got for our DEA Schedule I license. This is what scientists refer to as the golden ticket, because it allows you the privilege of purchasing cannabis from our federal government. And you'll see when we got this, finally obtained this about 6 years ago, the first one, we immediately, moved to order 8 kilos of cannabis for that clinical trial, and you would think it would come by like armored truck or something. Here's the FedEx gentleman there too. He had no idea he was transporting cannabis. He was kind of mystified why we were so enthusiastic, but this was a historic day for us. We had been battling the government for 7 years in order to get that document. And you can see this is how it arrives in these frozen packs that are, there's these little Ziploc bags that are labeled very minimally, and when you pour out the contents to meet the the DEA drug accountability logs, I'll show you some of the pictures of that. But I want to just point out that the only information in that box is this page, which is basically just tells you only the THC to CBD ratio. So we do not have access to the drug master file, which I would always have access to if I was doing other clinical drug development studies. I would always be allowed access to look at the properties of the drug that I'm administering to patients. It's just basic, basic protocol. But you can see on that page, this is a blow up of a warning that's on there saying that basically this plant is contaminated with mold and other microbials and should be irradiated before use, which is absurd that they're handing that out to scientists and asking us to remediate contaminated cannabis. It's unbelievable. So anyway, this is some pictures of, in previous years, the University of Mississippi was providing this in rolled cigarettes. And when you dump out the contents, you can see at the top there, how it's full of stems, sticks, leaves, seeds. It's not just the bud material. And that's what we're protesting, is that this is, you know, if we were allowed to study natural flower only, not with all this extraneous material, we might have different outcomes. And you can see at the bottom, that was a picture of our most recent batch of cannabis that arrived at the lab from NIDA. And you can see it's more of a green powder now. And that's, I think, as a result of us, of scientists like me who are criticizing the quality. Now they've just pulverized it into a powder, so you can't really discern what's in it, but it's pretty much the same. And I just want to mention that in order to receive this substandard material, I have to sign a document basically releasing our government from all liability. I am taking on all the liability as a scientist. It says that I hold the government harmless, and I accept all potential liability for any bad outcomes that the patients might have. And you cannot get that drug without signing that. So that's frustrating. Then you'll see on the, if you go on FDA.gov, you'll see a list of what they consider GMP requirements for why they would release study drug to scientists. And you can see number 23, that there has to be a lack of fungal growth. And that is not what happened with the study drug that's been going out to scientists for decades. It's had excessively high levels of mold in all the batches. This is the amount of money that is being offered every 5 years. It's under the, gives the public the impression that this is a competitive bid process, but it is not. There's only one entity really eligible for that funding, and that is University of Mississippi. So $68 million every 5 years being made available. And we were the first scientists to ever do secondary independent testing on the NIDA cannabis, and found these sky-high levels of mold in all our batches that would have never been allowed in any state test. When in state licensed cannabis, this would have failed testing immediately and would have been required to go for destruction. So I just want to mention that this is, the binder for our last veteran in the last clinical trial. And it took us 10 years to complete that study. And so let me just leave you with this. This is the regulatory pathway for doing, Andrew mentioned earlier how crucial it is that we conduct research on cannabis to understand more about how to harness its potential and what varieties of cannabis are best for which illnesses. All these are still questions that people have, but yet here are, each of these boxes represents different agencies that we have to hurdle in order to conduct our studies. So you can see why it took us 10 years to actually get this across the finish line. And I know I'm almost out of time. I just wanted to make sure to explain to people that this monopoly at University of Mississippi was granted back in 1968. So it's over 50 years old. And if your, research is not accepted by NIDA, then your study becomes impossible to conduct. So that's why this is really an attack on scientific freedom. It is the only federally legal drug supply for every controlled trial in the US. And this is, I'll leave you with this. This is our next study that we have approvals for. We're looking at smoked cannabis flower for treating advanced cancer patients. And I'll talk more in the Q&A about how, where we're getting our study drug, but that's all. Thanks, Jody.
Thanks, Sue. Just a quick question. If you chose not to use UMISS cannabis, what are your other options? I mean, you're telling us that you don't really have any, but why can't you explain why you can't go to your local dispensary and buy some good quality cannabis?
Oh, that's a great question. Yeah, the issue is, you'll notice at the bottom of this slide that we are attempting to import cannabis flower from Canada now, because that is our only option. You will not be able to achieve approval from an institutional review board. You must have, anytime you do human studies in the US, there's an international treaty that requires that you get IRB approval to make sure that patient safety is protected and all that. And if you don't get IRB approval, your data is impossible to publish. No peer-reviewed journal would ever publish this. But I just want to point out that here's an example of our attempts to import cannabis flower from Canada, which is the only way around this NIDA monopoly currently to import it from foreign growers, that you can see that we attempted to import from a LP in Canada called Afria, and the flower was contaminated with 3 different mycotoxin. And so this is what the struggle that scientists are dealing with. And yet, you know, here I'm hoping this will lead us to the discussion about the fact that, you know, our government promised us, they announced on the Federal Register back in 2016 that they would finally license other domestic growers for research. But as we're going to talk about more, there hasn't been any movement.
Okay, thank you, Sue. That was very interesting, and I'm sure that we'll have some more questions for you. Let's move over to Shane and Matt, litigators in Houston, Texas. And I guess, why don't one of you start off by telling us how you met Sue and how you came to be her lawyers and file some pretty successful lawsuits against the federal government of late.
Sure. Thank you, Jody. It's a pleasure. Thank you to the NCIA. It's a pleasure to be on here and share with you our journey with Sue. We picked up probably year 7 of Sue's journey. I met her at South by Southwest in March of 2019, giving a presentation like this one, which is why these presentations are very important. I was an audience member at that point, and I listened to her presentation, and I knew just enough about what was going on that I knew who I needed to talk to. And that was my colleague, Shane Pennington, who's with us today, who worked 2 offices down from me. I listened to Sue's problem about how her application was pending for 2.5 years. And, you know, I knew enough about what she was talking about where I was like, that's an administrative law problem. And so I don't do administrative law. That's not my wheelhouse. I do it. I've been working with Shane on doing it, but Shane that's his thing. So I exchanged information with Sue and said, look, I don't know if I can help you. What I'd like to do is I'd like to take this issue back to my colleague Shane and see what he thinks, and we might be able to represent you pro bono to get your application moving. It seems like there's something wrong here, but I can't really tell you exactly what's going on until I talk to Shane. So I guess I'll pass the baton to Shane. I go back to the firm, I hand it to him, and here's what he thinks.
Yeah, I mean, just to keep it brief, first of all, thanks to NCIA for having us, and thank you all for being here and being interested in listening and taking the time. Yeah, we took it back to the firm, and once I, looked at it, I realized it was going to be tough. It's always tough to get the government to do something it doesn't want to do. But we had a couple of legal vehicles to try it, and so we pitched it to our firm, and they gave us the go-ahead. And that started us down a rabbit hole that we're still up to our eyeballs in right now. So I guess I'll just leave that there, and we can fill in more details as we go.
Okay. Well, why don't you, Shane, why don't you start us off? You filed a lawsuit on behalf of Scottsdale Research Institute and sought to, let's talk about the first lawsuit, the mandamus one first. And maybe this is a better question for Matt, but tell us about that lawsuit and what the outcome was, and then I'll move on to some of the other questions that we have.
Sure, yeah, I'll take that one. Like Matt just explained, Sue's application to manufacture marijuana for research that just got kind of caught in a regulatory limbo or purgatory, and the government wasn't acting on it. And so what we did was we filed a petition for writ of mandamus, which was in the DC Circuit, the U.S. Court of Appeals for the DC Circuit. It's a court that I clerked in. It's a very important federal court that handles a lot of challenges to agency action in the United States. And we asked that court to order DEA to stop delaying and to start processing these important applications and get this important public health program going. And the DC Circuit basically asked the government for its response, which is itself kind of unusual in this context, because asking for a petition for writ of mandamus is asking for pretty extraordinary relief. And normally the DC Circuit just kicks them automatically. So that was a really good sign for us that they asked for the government's response. And so we thought, all right, well, you know, we're not getting shut out, so to speak. And when the government responded, it didn't actually respond to any of our allegations. It didn't dispute anything we said. Instead, it said, we are going to give you what you want. We're going to start the process. We're going to publish notice in the Federal Register of all of the applications we've received, and that will get this process going. Importantly, though, in the same breath, in the same public document, the government also said, however, before we're actually able to process your applications, we're going to need to do an entirely new notice and comment rulemaking to change our regulations that govern the process for granting or denying applications for registration to manufacture marijuana for research. So in other words, here you go, we're starting the process and then we're immediately delaying it again so that we can do a notice and comment rulemaking, which Jody, I know you know, and people who are familiar with this know, can take years. And so that was a sort of good news, bad news situation.
And there was something that came out in that litigation and in the NPRM that did follow, right? There was some hint that there was something by the Department of Justice behind all this. And that led you guys to file another lawsuit more recently under the Freedom of Information Act. Tell us about that, please.
Yeah, so Matt, do you want to talk about the
Sure.
The FOIA lawsuit?
Sure. So, you know, we did a lot of preparing to the petition for Scottsdale Research Institute in the first lawsuit. We had done a lot of digging into the facts and really kind of trying to piece things together. And there was always this piece that was missing. It was what's going on here? And part of what we had hoped was we would file this petition for writ of mandamus, and then after the court-ordered response, we would hear from the government, this is why these were delayed. Then we got back instead this very short filing, which said, oh, the case is moot. So immediately Shane and I put our heads together and like, well, what are they hiding? There must be something that they're hiding. And we looked carefully at the timeline, and then there was a Wall Street Journal article which sort of led you all the way up to the water, but didn't quite get you there, which was that the Office of Legal Counsel had stepped in. And the Office of Legal Counsel is like the Justice Department's lawyers. They're like the in-house legal department for the Department of Justice. And, you know, when they get involved in something like this, they usually produce some written opinion, which then becomes the law of the executive branch, the law that our executive branch follows. I just, you know, recently, I guess with the Ukraine whistleblower complaint, that was an example of where the Office of Legal Counsel wrote an opinion saying that this whistleblower complaint didn't need to get turned over to Congress, and therefore it wasn't. So OLC gets, they do weighty matters, important matters, and they write opinions that bind the executive branch. And so we have our lawsuit, and then we have this notice of proposed rulemaking, and Shane and I are looking at each other like, well, where's the memo? I mean, where's the document that told DEA and DOJ that they had to do all this? And so we realized that, I mean, there was a memo, but they just weren't disclosing it. These OLC memos are very secret, actually. I don't know how many there are, but suffice to say that there might be more. There probably are more secret memos than there are public ones. They publish them at their discretion, and they did not publish this one. So,
and why did you think that you needed it to actually comment on the current notice of proposed rulemaking?
Well, in an ideal world, the purpose of the notice and comment is for the agency to say, we need to do this. This is why we need to do this. You know, we considered alternatives. and whatnot. And it allows the public to sort of, offer their perspective, which is different from that of the federal government, and to create a better rule in the long run. Instead, what we got a rule that said we considered alternatives, but there were no alternatives. And we were like, well, why were there no alternatives? How could there possibly be no alternatives to what you're doing? The agency was saying, well, this is all legally required. And there were hints in that about like the treaty, convention, whatnot, but it still like left a lot of questions of like, okay, well, exactly why? And then, I think most important, why was the process delayed for 2.5 years? I mean, why is this taking you so long to do? And I mean, it's easy to say in response to our lawsuit, that's why they went ahead and did it, but why did we have to file the lawsuit in the first place? So there were a lot of important things, and all of that, and I'll finish the thought there, which is all of that is important to sort of protecting your rights in the administrative process. You have to, the administrative process is a very finicky one, I guess is one way of putting it, where you have to be very diligent about making, telling the agency what your position is. If you ever want to later challenge it, you have to tell them what your position is the first time. And so we wanted all of as much information as possible so we could tell them, look, we think your rule is good in this regard. We don't think it's good in this regard. And that's the basic gist of why we needed that document.
Okay, and you actually won that Freedom of Information Act lawsuit, did you not? And you got the OLC memo.
Rather quickly. We filed a complaint, and Shane and I worked very hard on drafting up what's called a motion for a preliminary injunction. It's something that you file in a court where you want to get preliminary relief because you want to keep the status quo. And our argument was that, look, like this deadline is in like 6 weeks. Like we need this decision decided now. It's something that we sort of thought carefully about. We've got COVID-19, like, do we really want to be bothering a judge with? But, we went to the government, we asked if they'd push back the comment deadline. They said they wouldn't. We did a couple other sort of litigation tactics. I won't go into those unless people have questions about them. But suffice to say, about 2 weeks after we filed the complaint, the government called us up and asked if we wanted to settle. And the settlement was disclosure of the document. Since that's what we were asking for, we said, yeah, okay, let's do it.
And Matt, why do you think that DEA didn't fight you on this? Why didn't they file a substantive objection in court?
There are a number of reasons. I'll start with number one, which is, Sue is a hell of a client. She has been doing this. It's a privilege to write up the facts in these cases, to show all of what she's been through and why she does the work that she does. And so I think point number one is DEA doesn't want to fight Sue. So that's point one. Point number two is I happen to work with a brilliant colleague named Shane Pennington, and I'm not too shabby myself, but we had zeroed in on a sensitive legal issue that sort of had broader import than just this one issue. It has to do with deliberative when the executive branch can withhold these documents, and we have the perfect fact pattern for taking a case like even higher than the district court. So we had great facts, and we have this sort of legal issue teed up. And everyone talks about taking their case to the Supreme Court and whatnot, and who knows, but our case it had broader import than just a single memo. And the last thing was, with all the COVID stuff going around, I think the DEA thought, well, it's probably just better to settle this and try to sweep it under the rug than, getting a headline that says federal judge orders a DEA to disclose this secret memo. It almost makes it even worse. I mean, it's bad enough that it was kept secret, but having a court force you to disclose something then really makes it seem like they were something.
Mm-hmm. And Shane, obviously after you got the memo, SRI filed comments. What would you have DEA's next moves to be in response to the comments?
Yeah, so if I ran the world and had all the discretion that DEA has, that'd be great. I don't. If I did, I would let me put it this way. There are really, the rulemaking is actually not about these applications. The rulemaking is about DEA's unfortunate mistake for over 50 years to interpret this treaty and the Controlled Substances Act wrong. And it's not my opinion. That's the opinion of the Office of Legal Counsel, the top legal expositor of the executive branch, that said in this memo that DEA didn't want to disclose, but now has been forced to, that look, DEA, your interpretation of federal law and United States treaty obligations has been wrong for, over half a century, and you can't proceed with registering any new growers until you change your rules. So that mistake, which is DEA's mistake, is now being used to sort of hold our already delayed applications in limbo even longer. And there's really no need for that. So while I agree with OLC that DEA needs to change its approach, I don't think that that should slow our applications down. And the Controlled Substances Act has a provision that allows the Attorney General, who's delegated this authority to DEA, to waive the registration requirements altogether when the administrator finds it in the public interest. And so if I ran the world, if I were the administrator, I would use that discretion to allow 1 or 2 or 3 or 15 or however many of these applicants to go ahead and start growing this marijuana for research. And I won't go on and on about it, but let me just put it this way. DEA says that it supports this research. DEA says that it's excited about getting new researchers involved. It's eager to do it, and both political parties, agree about this. This is not a controversial thing. So really, the question is, why wouldn't you use that discretion that Congress gave you, that flexibility in the joints, when there's been all this delay that Congress is upset about and that so many are upset about? If you really do want to get the research going, here's the tool that Congress gave you to do it. That's what I would use.
Mm-hmm. Are you crediting the good faith of OLC in writing that memo? Do you, as a sort of rational litigator, believe that actually the interpretation of OLC that DEA had it wrong for the past 50 years is correct?
So I think I heard 2 questions. Do I think that OLC was acting in good faith? And then do I think that the interpretation in the OLC memo was correct? Yeah.
Either or both, or none, if it's too controversial question.
As SRI's lawyer and as a professional lawyer who's handled a lot of matters against the government, I found that it's actually a lot more complicated how these things actually break down in real life than it might seem from the outside in every case. So I'm very slow to question the good faith of the government in these processes. Most times the actual decision makers who are doing things that you disagree with are acting in good faith. They sometimes don't know all the information. There are a lot, it can get very complicated. As you know, I think you could probably speak to this. With OLC, it's interesting because it's a very small office and it has a very discrete and important function. And so I think that they knew what was going on. I just am slow to question their good faith. They are, however, testing the limits of my my professional patience at this point, I will admit. I'll just add that it's really you're not doing yourself any favors questioning their good faith, because courts give them a presumption of good faith. It's pretty hard to rebut. Okay, so now going on to, do I agree with their interpretation? No. In a lot of ways that I could get into, I will say that it's a lot better than you might think. I mean, OLC's a bunch of smart people, and they took a lot of time. It's 25 pages of dense legal argument. The most important thing I disagree with is the idea that DEA needs to remake the wheel before it can let this very important public health program go forward to get research that's necessary for veterans and children, and that both political parties agree with, that needs to go forward. There's no need to delay that. That's not what the Controlled Substances Act or the Single Convention says. There's a lot more that I could say, but I'll just leave it there.
All right, let me ask you each one more question, and then we'll move over to Andrew. So, Matt, for you, what lessons or insights or takeaway can we learn from SRI's litigations to date?
Well, I guess one of the things is I feel like we're sort of at the threshold of impact cannabis litigation to some extent, you know, and getting movement on some of these issues. I mean, I think that we've gotten successful court outcomes, but we've also ignited a conversation about, or reignited a conversation about the issue. Our first lawsuit is now cited as authority. Our petition is cited as authority in the Congressional Research Service. It's been cited now in the New England Journal of Medicine. Lawsuits can be a good tool for publicity. They can be a great tool for helping legislators, helping the conversation. I think at least Shane and I think that there needs to be legislation. There's no doubt about it. We're not trying to file lawsuits and get it changed that way, but you know, Congress has been trying, and it hasn't been working. So maybe we file some lawsuits, point out some problems, the fixes will come in sooner. So for lack of a better term, litigation tends to light a fire under someone's behind. So that's one good thing. I think the second thing is Shane and I have a very, you know, we've approached these cases like very delicately. And what I mean by that is, you know, rhetorically, we try to keep it very in check. We have a lot of respect. You know, one thing, just I remember this in all my cases, is look, the person on the other side of the V usually is just doing their job, and they're just representing their client. And so, you know, we don't think that, you know, the drug war is a just cause, you know, and all that stuff. But when it comes to our litigations, we're very focused on the issues, try to keep our rhetoric in check, and focus in on our client sue or problem, and go to and so when we go to the judge, we say, look, we're just out of options. We're here, we're out of options. And so I think that's effective advocacy. Effective advocacy is being a worthy plaintiff, having a worthy cause. And then when you show up, and that takes, you know, cannabis right now, medicinal cannabis has widespread approval. Cannabis is getting, just regular legalized cannabis is getting there. But the federal bench, I still think is a little uneasy with it. So I think the second lesson you can learn from our litigations is, like, find a good, like, if you're litigating cannabis, even if it's just a contract dispute in court, right? Make sure you have a good client who has a worthy cause, and I would, you know, rhetorically, like, you know, be very conservative about it, and it's worked for us so far, and we're hoping we can continue with that success. But yeah, litigation can light a fire under some people's behinds.
Yep, a polite litigation.
Yeah, polite, yeah, exactly.
So, Shane, last question for you. Does this have wider implications in your view, and maybe particularly in light of Andrew's comments at the top? You know, there's something to say about, you know, why this legal drama should matter to anybody that's not, you know, a potential cannabis cultivator.
Yeah, so let me start with just sort of like the cannabis industry, and then let me talk just briefly about even broader than that. When it comes to the cannabis industry, a day of reckoning is sort of coming. You know, there are going to be big changes where the industry is going to be legitimized one way or the other under federal law, and it's going to be regulated under federal law. And at that point, there are lots of questions about who, meaning which agency, is going to be the sort of head regulator, and how are they going to treat and view and process the industry compared to other regulated industries in the United States. And, you know, I think right now the government knows that's going to happen. And so they are taking important steps right now to sort of prepare. And when they're doing things in secret behind closed doors, and when they're doing things that create massive changes in law through secret documents that, you know, they hide away from the public and from Congress, that's a bad sign. And it's important for everyone in the industry to sort of not bury your head too much in the sand, I know that there are reasons why, people might not want to get involved in the federal regulatory arena at this stage. It may not seem like the most important thing, but if it does become more important in the future, you're going to need to be able to represent yourself strategically, and you're going to need to have good working relationships with the federal government eventually, probably. And so it's time to sort of put, it's like when you're in a new relationship, you need to draw some boundaries. You know what I mean? Like, hey, if you're going to change my life drastically, don't do it in a secret memo, please. Thank you, right? If you're going to delay me for 4 years, that's fine, but I need judicial review of that with a record, for example. Okay, so now just more broadly, people are pretty upset about what's going on out there in the world and, right now. And just to use this, I saw in the comments, I can't remember, I think it was Christopher Jennings said, knowledge is power. The reason that this matters is because we cannot allow the government to run our lives in secret. The DEA has just asked for and received the power to use clandestine tactics to surveil protesters, okay? And I'm not trying to make a normative claim about all the complicated issues that are facing the country right now. What I will say is that it's important when we're in these difficult times to make sure that we abide by the rule of law and keep it sort of sacrosanct. And it doesn't surprise me that this particular administration's DEA wants to do things in secret, doesn't mind, asking for that power, and that they've been given it. And again, this is a time where you need lawyers, lobbyists, funding to get out there and say, look, this is not going to fly, okay? We're perfectly happy to work with you, but we need to be treated with respect and with the rule of law. And that goes for protesters. You could, like, if that's how they treat us, that's how they're going to treat you. You know what I mean? And it kind of goes across the board. And so now is the time to really get involved and speak up.
Thanks so much, Shane. Andrew, obviously the NCIA also filed public comments. I know that you've certainly done some webinars on the public comments, and I'll assume that people in general know what NCIA said, but can you tell us about what moved NCIA to file comments in response to the NPRM that DEA put out about cannabis cultivation licenses?
Yeah, thanks for the question, Jody. It's sort of a two-part answer. One is democracy requires public participation, right? So just like Shane was talking about, we have to stand up. We live in a democracy, so we have to engage with our government. And when we don't like what the government's doing, we need to be vocal about it. We also have a duty to our 2,000 members to respond to any notice and comment rulemaking that's out there. At a personal level, like you, Jody, and similarly to Shane's point about questioning the good faith of the government, I spent 14 years at DOJ. I was a political appointee in the early days of the Clinton administration, and then I spent 6 years as an assistant U.S. attorney and 6 years as a civil rights prosecutor. And I have the utmost respect for DOJ, and that includes DEA. But I'm simultaneously disgusted by the politicization of the Department of Justice, and I think in this instance, the DEA too. And so that was part of my individual motivation, was to call out the DEA for what I saw as a power grab, an inappropriate power grab.
And what are the crux of, so let's say those are the big picture items that caused NCIA to act. What are the crux of the comments that NCIA put forward, for instance, in response to DEA saying, we're going to buy all the marijuana that our licensees cultivate, and you have to turn it over to DEA within a 4-month period, and we're going to set fair market value. Oh, and by the way, you cultivators will pay for the privilege and the cost of running all this. What are your concerns here about DEA being in the middle of this process to begin with, and then some of the individual elements of what they propose as process should they ever grant these licenses?
The first is DEA is a law enforcement agency, and research is a public health issue. I don't think that is debatable. And so, why is the federal government putting a law enforcement agency in charge of research? It's nonsensical. So, it's our view, and we put this in writing to the DEA. The DEA should withdraw this notice and comment rulemaking, and that OMB should put this in the hands of a public health agency that understands the complexities of the issue, understands the import of the issue. And that's likely, NIH or some other division of HHS. We were also struck by the reliance on the single convention. Just this week, with all that's happening, it's hard for me to keep track of whether it was this week or last week, but the president pulled out of the World Health Organization. He's rallied against every international treaty under the sun, right? I mean, PPP, the Trans-Pacific Partnership, the UN, the list goes on and on and on. And so why now, is DOJ suddenly relying on a fairly antiquated treaty to justify their actions? It just seemed confusing at best and rich at most. Like, why now? And I appreciate what Shane said. At OLC, there are, the smartest lawyers in the country work in that office. There's no question about that. And most of those people are career public servants who are well-meaning and well-intentioned. But I find it hard to believe that under the William Barr administration that they haven't been tainted. And that's really disconcerting. So our view is the most obvious path would be to pull out of the convention, object to the cannabis provisions, and then re-enter if they in fact feel that strongly about relying on that treaty. One of the other issues that really struck me, and Jody, you and I talked about this, is DEA says they won't consider prior compliance with federal narcotics laws in granting or denying registration, meaning they believe that if someone has been operating in violation of the Controlled Substances Act, that they're not eligible to do this work. And that is just insanity to me. It's like, you're now saying, okay, just from a public policy perspective, putting aside the Controlled Substances Act, like, you're now saying the most experienced cannabis growers in the country, people who have been doing this for 20 years, are not going to be allowed to do this work. And we're going to now trust someone who's been growing pumpkins and pumpkins and potatoes because they weren't technically in violation of the Controlled Substances Act, that they're going to be able to do this work. It makes no public policy sense. So that was a big piece. Some of the smaller issues were the proposed rule grants, transfers the burden of proof to the applicant. It used to be that the DEA had the burden of proof. So if you were denied, you had the ability to have due process and a hearing. And that no longer exists, evidently, in this rulemaking. And DEA can just basically deny your application, and the burden is on you to prove that they're wrong. And if you don't have a lawyer like, Shane and Matt in your corner, you may not know what their justification was, right? Because you may not have seen that information. So those are the main issues,
Okay.
And the reasons that we objected.
So Sue, let me go back to you to close it out, and then Andrew, maybe I can turn it over to you for questions from the audience, because I've seen quite a few popping up. Sue, I believe that the NPRM also says that basically they're starting all over with the cannabis cultivation licenses, and everybody has to refile, essentially. Are you and other scientists going to refile? Do you have hope that you might actually get a license out of this one if, in fact, the NPRM becomes law?
Wow. I don't, I was hoping my attorneys would guide me on that because we're, I mean, certainly we're not going to relent until we fix this situation. This is, just such a clear attack on scientific freedom, and scientists deserve access to options. And this is the sad reality, is that I'm speaking on behalf of all the scientists because none of them really want to participate in this battle. It's too risky for them. A lot of these guys are receiving federal grant money and they can't afford to challenge or criticize the government in any way. But let me see if the attorneys want to talk about whether we'll reapply, or but we'll keep moving forward. I just want to assure the
Sure.
government that we're not going to abandon this until we finally dismantle this monopoly. And I mean, ideally, we would be allowed to grow for our own clinical trials, but if not, at least I'd like to see a handful or more of new new domestic growers here, so we can have access to real world cannabis that represents what people are actually using day to day, and the diverse genetics that are readily available in regulated markets. I know there was a question on the chat about the Yale situation. Yale recently got approval to do sort of a modified randomized controlled trial using state licensed cannabinoid product. And this is a brand new breakthrough. I would say in 50 years, nobody has achieved this. I would say it's a little bit complicated, that situation, because it's not a classic controlled trial. And observational studies, you're allowed to use any cannabis you want to observe, as long as you're not touching the can or randomizing it. So they found a path using the IRB at the Yale University, but typically IRBs have not been willing to approve that, and they won't approve. Their IRBs are federally regulated, and they all adhere to the same rules, and they're not willing to allow for anything except federally legal cannabis. So we'll see how that plays out.
All right, well, good luck, and let me turn it over to Andrew. So Matt and Shane, just to give some voice to the audience members. Sorry, Andrew, do you want to throw out the questions that are out there, or?
Sure. Yeah,
we've got
we've got a number of questions here, and I've been looking through them. And Gary Hess poses a question, which I think is the fundamental question for the cannabis industry right now. It is the most important question that we need to answer. And I'm going to pose the question to Jody, if you don't mind. And if you don't want to answer it, I'm happy to answer it myself. But the question is, how does rescheduling versus descheduling impact the cannabis industry as a whole?
I mean, it is a huge question, Andrew. And obviously, look, rescheduling from Schedule 1 to some other schedule within the Controlled Substances Act will put cannabis in the place of, pharma, basically. Think of those who make OxyContin, to take an example, and the regulations that come into play. And imagine now independent cannabis growers, dispensaries being subject to the massive regulations that are the Controlled Substances Act and the regulatory scheme under the CFR. And imagine what the costs would be, and can those ever be recouped, and can they ever compete with big pharma or big alcohol or big tobacco? So that's what rescheduling would do. Descheduling would just make it not illegal federally, and there are still quite a large number of people out there, powerful entities, who do not want to see marijuana, cannabis completely descheduled and made legal. And there is the States Act, for those of you who follow, creative congressional approaches, which says, listen, keep it scheduled, keep it where it is, but let the states control this issue. And at the beginning of this administration, people were very hopeful about that, because this administration came in with a hugely federalist bent, that suggested that states should have power to regulate its own state-focused behavior, prevent interstate trafficking, of course, prevent selling pot to kids, but really the States Act would be the solution, and it's neither de or rescheduling. But those are the differences between sort of the three main options that there are out there.
Thank you.
Hope I answered your question.
You did, and it's such an important issue that I do want to ask Sue a related question, which is, Schedule 1 indicates that there's no medicinal value, right? Like if you're in Schedule 1, as marijuana is, the federal government has determined there's no medicinal value, and we know that's fundamentally irreconcilable with reality, starting with the fact that the federal government has a patent on medical cannabis. So I would just ask Sue if you have any thoughts about moving cannabis from Schedule 1 to a different schedule versus descheduling.
I think, well, typically rescheduling has not been able to happen without, FDA controlled trials to verify safety and efficacy that would warrant moving it to a lower schedule. But I think our attorneys have found a way around that through this recent litigation that we're hoping would make that possible. But I would say, the medical benefits have been well documented. We have thousands of controlled trials now that have verified the efficacy of cannabis for treating, and especially because besides the patent, we have the National Academy of Science report from over a year ago, which was issued, by a really respected federal agency, confirming the opposite of what the scheduling says, and basically confirm that there's strong scientific evidence to support cannabis as a treatment for chronic pain, for nausea and vomiting, and for the spasticity associated with MS. So I think that just based on, there's an immense bank of controlled trials now that have already published their data, and I think that I think probably Matt and Shane can explain, but there is a mechanism to allow for rescheduling that would still, I don't think, as much as I know the cannabis community wants to see this fully descheduled, there are, concerns. I mean, we see in our lab every day patients who do have adverse events associated with this. It's not a benign drug, but it's also not worse than most of the pharmaceuticals that I write for patients every day that have a laundry list of side effects. So I think the side effect profile of cannabis is still benign, but it's not without side effects, and there's still things that are concerning for public health. So
we need research.
Yeah, exactly. That's it.
All right. We have been authorized or asked to stay on for another 5 minutes to answer a few more questions. If the panelists need to jump, I understand. But here's a question from James Schwartz. He says, does anyone on the panel have an idea of when we will start to see movement in the industry due to the pressure being applied by the lawsuits? This may be a good question for either Matt or Shane.
Well, the lawsuit that Sue is recently alluding to, if we were successful, would certainly cause some pressure. But I actually think, set our litigations aside, I think that this election is going to be the most important event. And actually that we're doing, I think, good stuff with our litigation. We're like I said, we're pointing out problems. We're providing Congress and legislators showing them the problems and offering solutions, but I really think it's going to be organizations like NCIA, local representatives, and voting in this election that's really going to push this issue over the line. Again, we can only do so much with litigation. We're good at poking holes, but we're not good at filling them.
You guys are doing amazing work, though. Deborah Mirren has a question, and this is again for Shane or Matt. Are you at liberty to speak to the latest petition filed on May 21st by SRI against DEA?
So I'll take this one. Yeah, we're at liberty just to say, I mean, it's public, and basically what happened was we found that DEA had denied a petition to start a rulemaking to consider the legitimacy of marijuana's placement as a Schedule I drug under the Controlled Substances Act. And basically, long story short, DEA had denied it through a letter that just sort of pointed back to previous rulings that DEA had put in place. And that's not really a legitimate way to handle such a petition. And so it actually gives anyone standing, that agency action gives anyone who, has, would otherwise have standing to challenge that action, the standing to go challenge it in court. And so we took that opportunity just to file this lawsuit. And really what it's about is pointing out some more of these problems that Matt's talking about. It has to do with like some really technical stuff about how we interpret the statute, how have they done this nonsensical thing of keeping something that obviously has accepted medical uses in a category where that's defined in terms of it not having those uses. And it basically boils down to some bad interpretations and legal rulings that from way back that haven't been challenged appropriately. And so we're making those arguments in the lawsuit.
Thank you. I just lost, for some reason, the question just disappeared. I don't know what happened. Oh, here it is. This is a question from E.K. McWilliams. Could anyone provide a quick breakdown of the DEA versus FDA roles in approving clinical studies? That's probably a question for Sue.
Yeah, I would say, there's a process. Usually you start with FDA first. They have to go in sequence. So FDA will evaluate your scientific protocol to verify that it's safe, ethical, all those elements. And then we would go to the IRB, the institutional review boards, either in the private IRB or university IRB, whatever, and they would decide if this is safe for human subjects. And then once you get that, then we would move on to the DEA, and they would decide if our plan for how to store the drug safely and prevent diversion of the study drug, illegal diversion. And so the DEA is mostly, they have an important role. They're making sure that we're protecting the study drug and accounting for every gram so that none of it is displaced. But so that's why I say with the title of this, of the webinar, I wouldn't say that we want to eradicate the DEA from research because they have a crucial role, but it should be that circumscribed to that minor role, and we're trying to persuade the government that they shouldn't be involved in enforcing this monopoly anymore. But they have an important role, and I would want to emphasize that the DEA has been very collaborative with us from the beginning. We've worked with them for 10 years, and they've never been anything but encouraging and willing to help us move forward, especially at the local level. So I don't know if Jody, in her effort, I feel like the agencies are sort of scapegoating the DEA and treating them unfair and hanging all the around responsibility on them. But it may be these other agencies that are actually perpetrating this, and they're just getting the blame for it.
So we just have time for one last quick question, and I think this is probably for Shane and Matt. And it's a question and a statement. It's from Gary Hess. Would it make sense to create a public movement behind your current efforts utilizing current social media platforms to bring unbiased awareness of your efforts? And then he goes on to say, this information should be made available in detail and daily.
Sure. Well, that's part of what we do when we file these petitions or complaints is we write these, you don't always have to file them very detailed, but we try to create these good documents that people can share that are not too legalese. But yeah, absolutely. Share this on social media platforms or whatever. Shane and I are really busy people. Unfortunately, we can't do everything. And Sue, she practices medicine as her day job. So, but yes, we would love help and bringing awareness of the issues. We've tried reaching out to Congress. And we do on a daily basis. We take an hour or two reaching out to people see if we could get support on our current lawsuit. But yeah, absolutely, we love people to share on social media and everything. I think that only helps. But again, I like the word unbiased. Let's keep the conversation civil. Let's talk about the problems. That's how people are going to hear this message, is when you put a problem and that and you just keep it very civil.
Thanks, Matt. All right, we'll turn it over to Brian.
Perfect. Thank you all so much. Let's give all these amazing panelists a virtual round of applause. If you enjoyed today's session, raise your hand. There we go. I love people doing that in the audience pool, and also post a quick chat room message letting them know what the best piece of information that you're going to be taking away from today's webinar is. As instructed, thank you all so much for the incredible engagement with the Q&A portion of the presentation. There's still about a dozen questions that we haven't been able to address. So please do know that we're going to pass those along to all the panelists and solicit some answers from them electronically and provide that to you via email or potentially in a post-webinar blog post. So stay on the lookout for the answer to those questions, and thank you all for participating. You all will receive a PDF version of this presentation. I know there wasn't a lot of slides incorporated, but definitely make use of this contact information slide at the end of the presentation if you have any follow-up questions or wanted to reach out to any of the panelists to directly support their work or their efforts. We do want to conclude the presentation with a quick upcoming announcements of some of our other upcoming events and leave you with a preview of the next Industry Essentials webinars that are taking place. So we hope you will all continue your participation by joining us for the next edition of our ever-expanding Industry Essentials educational webinar series taking place next week. On Wednesday afternoon, we have another edition of our NCIA Committee Insights series entitled, How Can You Get More Engaged with NCIA? Let's Talk Committees. In case you missed it, applications for NCIA's committees are now open. Committees are the heart of NCIA and one of the best ways to take advantage of your membership and be an active participant in our community. As an active committee member, you will be able to network with other professionals in your issue area, influence policy, create content promoted throughout our networks, and overall raise your visibility amongst our network. But just don't take our word for it. Hear firsthand from the chairs of some of our committees about their experience being on the committee this past term and the highlights from that year. This talk will feature Rachel Kurtz-McElwain, Deputy Director of Public Policy here at NCIA, Alina Rodriguez, Managing Director at RM3 Labs, Michael Cooper, Managing Member at Madison J Solutions, Trevor Moronis, Founder at Control Point, and Janine Moss, the co-founder of Outfront Solutions. If you're a frequent participant in our webinar series, you all recognize those amazing panelists as some of the moderators over the last month and a half. So you're really in store for a great presentation next week. Look, we've all felt the hit from the lack of exposure at in-person events these past few months, and as always, NCIA is here to assist. We're offering a number of incredibly valuable digital marketing packages across all our highly trafficked platforms. So head to our website to learn more and schedule a meeting with one of our biz dev team to discuss in more detail today. And last but not least, I would like to formally invite all of our NCIA members, of which there is about a 60-40 spread I did see in this webinar today, to attend the debut of our new Cannabis Caucus Cyber Series next month. We're taking everything you love about the Cannabis Caucuses and reformatting it into a one-of-a-kind virtual experience. To kick things off, you'll receive exclusive access to industry insights delivered firsthand from national and regional leaders in the space. Next, we'll conduct a live Q&A session with audience members to provide the interaction you've come to expect from participating in an NCIA event. And finally, we'll conclude the evening with a happy half hour featuring an exclusive live musical performance that you'll all be able to participate in while interacting with your regional network and partaking in our curated libations and recipes for the evening. We will be hosting these events in the locations we had to cancel in March due to COVID-19. And while these, of course, will be regionally focused gatherings, feel free to tune in from anywhere you may be. Always wanted to participate in all our regional Cannabis Caucus events, but never had the time, money, or physical ability to be in two places at once. Well, we finally have the solution for you. So what are you waiting for? Activate your NCIA membership today if you need to, then sign up today, kick back, light up, and put your headset on. This will be the new way for NCIA members to stay connected, get informed, and take action in cyberspace. And with that, thank you all so much to our panel of all-star experts and all of you for participating in another NCIA Industry Essentials educational webinar this afternoon. Please complete the attendee survey after leaving the meeting room to gain immediate access to our presentation and exclusive 30-day access to a formatted video recording sent directly to your email inbox. Let's give these amazing panelists one last virtual round of applause, and I hope you all enjoy a wonderful week, and I look forward to seeing you all again next time for another NCIA Industry Essentials educational webinar. Have a great day.